Welcome back to our lecture series on JIGL, Jurisprudence, Interpretation and General Law series. In the last two videos, we explored the meaning of jurisprudence and met some of its key contributors and thinkers who laid the foundation for how we understand law today. In this video, we are shifting our gears to examine the schools of law. We will begin with natural law school, which argues that law is rooted in morality and universal principles. Next, we will look at analytical or a positivist school. This school separates law from morality, focuses on studying law as it is, which is created by authority. Then comes historical school of law, which sees law as a product of society's custom, tradition and historical development. Okay, each one of them have said different perspective on law. Again, I repeat, natural law school focuses on morality. Analytical school focuses on studying law as it is without adding morality. Historical school says about how law is evolved with the society's custom, tradition and historical development. Next one is philosophical or ethical school of law, which believes law and ethical practices are correlated. Now, we will also touch upon sociological school, which believes in law as a tool for social engineering. What is social engineering? That we discussed in a key contributor section. You can refer those discussions. Finally, we will introduce the realist school, which challenge the idea that law is just a set of rules. It is all about what judges actually do in practice, not just what it is stated in a statutes. Okay, realistic school is the latest one, which is evolved in America. So we will go through one by one in detail in the next slides. Let's start our journey with Natural School of Law. Let's explore now first major school, which is Natural Law School, one of the oldest and most influential legal philosophies. As I told earlier, Natural Law School is rooted in the ideas of certain rights are inherent to human being simply by virtue of being a human. As he is a human being, he will get some rights. No government can grant those rights. These rights are not granted by any government, and these are or any other authority. They exist naturally because they are human beings. According to this law, according to this school, law is not just set of rules. It is a it reflects a higher principles that are immutable and eternal. So divine is a most important aspect of natural law school. So they say that all these principles, higher principles are immutable. Even any law passed by authority, the higher principles as a human being, what all I should get, right? Those rights cannot be changed. These all are immutable and everybody should get these rights. In fact, natural law holds that any law which contradicts these higher moral principles is invalid. If any law violates that fundamental rights of an individual person, those basic rights, then these all laws are invalid. So, in the natural law school's view, law must be based on the ethical values and universal justice. So this school is also known as divine law or the law of the God, because uh, many religion aspects played a greater or a significant role in shaping this law's foundation during natural law school principles. Many early thinkers believed that law was divine, inspired and aligned with spiritual truths. Okay, many early principles proposers, they believed that law is all about aligning with the spiritual truth, and laws are inspired by divinity. Philosophically, natural law is based on priori propositions. Priori propositions meaning knowledge that is acquired independently of experience. Okay, priori propositions, which means knowledge which is acquired independent of any person's experience. It is not about trial and error, it is already experienced and then it is written. There are two key stands within natural law. One sees it as a divinely obtained and rooted in a religious belief. That is what we discuss, right? Law, natural law is also called as a divine law. So one set of people saw that it is a divinely already ordained and rooted in religious belief. The other set of people who are more philosophical sees that it is all about basic human rights and maintaining those or protecting those basic human rights. To understand how natural law evolved over a period of time, we will break it into four key historical phases: ancient theory, medieval theory, Renaissance theory, and modern theory. Let's begin our journey through the natural law school, what its earliest phase thinkers thought, that is ancient theory. This is where the foundation of legal philosophy was laid by some of the history's greatest thinkers from Rome and Greek. So first let's see from a Roman side, we have Ulpian. Ulpian, a Roman jurist who defined law as the art or a science of what is equitable and good. So it is all about what is good and what is equitable, what is the equality, like equity. Okay, so the art of or science of what is equitable and good. This definition emphasizes fairness and moral goodness as the core purpose of a law. So morality is a main purpose of the law, that is as per Alpine. Cicero, another towering figure, described law as the highest reason implanted in nature. For him, law wasn't just a social construct. It is not constructed based on social things. It is the highest implanted. This is the highest reason which is implanted in nature. It was a reflection of universal reason embedded in the very fabric of the nature. So very clear, it is not written by someone else. It is already part of a nature. It is not written based on the social construct. Then Justinian's Digest, a monumental legal compilation, defined law as the standard of what is just and unjust, what is right and what is wrong. Moving to Greek philosophy, Hercules was among the first to articulate the concept of natural order. He identified three key features of a natural law: destiny, reason, and destiny, reason, and order. He believed these elements were deeply interconnected, forming the backbone of cosmic and legal harmony. Socrates, a prominent philosopher, introduced the idea of human insights, the internal moral compass that helps individual distinguish between right and wrong, what is right and what is wrong, right? So law is the moral compass that helps individual distinguish between what is right and what is wrong. So he saw this insight as parallel to a moral law. Then Plato, is a disciple of Socrates, built on this by emphasizing wisdom and reason as the pillars of natural law. Plato said that wisdom and knowledge are the two pillars of natural law. So according to Plato, law should reflect the rational and wise nature of the human soul. Finally, Aristotle offered a profound definition of natural law. Law is reason unaffected by desires. Okay, the reasons unaffected by desires. He believed that law arises from the inherent nature of man, shaped by human insights, and that is guides our will, action, and sense of justice at the deepest level. Together, these thinkers laid the philosophical groundwork of natural law, linking law to a morality, reason, and the universal order. Their ideas continue to influence legal thought even today. Let's now move into the next two phases of natural law evolution, medieval law and Renaissance theory, each reflecting a distinct worldview and philosophical foundation. Medieval theory, this phase is deeply rooted into theological thought or a divine thought. Law during this era was seen as a divine command. The law of nature was essentially the law of God. So dharma or a religious played a greater role in this particular phase. Famous thinker of this phase is Thomas Aquinas. He is a major exponent of this theory. He categorized law into four categories: law of God, natural law, divine law, and human law. Law of God is a eternal and it is a wish of a God. Natural law accessible through human reasons and reflecting the God design. Natural laws are made with a God's will. And then comes a divine law which will be taught through scriptures and religious teaching. Final one is human law created by societies, but these all are valid only when these all are aligned with the higher laws like law of God or a natural law and divine laws. Moving on to Renaissance theory, we see a major shift. This era is marked by rationalism and growing emphasis on human reasons. So in the medieval theory, we saw that human laws are a last of priority, but all the human laws must follow the superior laws. Here it is the emphasis was given on human reason. Law begins to move away from purely religious foundations and becomes more secular and political. This has become more secular and political. Two key features define this phase. Law is grounded in human reason, not divine revelation. It advocates for the natural rights of individual and the state. It advocates for the natural rights of an individual and the state. Major proponents in this era were Hugo Gracius, often called as the father of international law. He built his theory on the concept of social contract. According to Gracius, the sovereign exists to protect its citizens and itself bound by a natural law. Another major thinker is Immanuel Kant, who emphasized that individuals are guided by their own conscience. For Kant, natural law is not just based on reason, it must be based on a right reason, meaning moral and rational judgment. Together, these theories show the evolution of natural law from divine command to human-centered rationalism, paving the way for modern legal systems. Next, we will explore the modern theory where natural law becomes the foundation for democratic ideals and individual freedoms. The modern theory marks a revival of natural law but with a twist. Unlike earlier versions rooted in theological and abstract reasons, modern natural law emerged as a reaction against the rigid frameworks of positivism and historical jurisprudence. It doesn't simply return to old ideas, it reinterprets them to suit the complexities of a modern society. The central idea here is that law must be just, not merely valid or historically evolved. It must serve harmonious purposes within the society, uphold the ethical standards. Okay, harmonious purposes within the society. So let's look at some of the key thinkers. Rudolf Stammler argued that natural law should be understood as just law, not an unjust law. Law that promotes social harmony and moral purposes. For him, law wasn't static, it had to evolve with the society's ethical ideas. John Rawls, a towering figure in modern legal philosophy, introduced the concept of justice as a fairness. Justice as a fairness. He emphasized that law must be designed to ensure equality and protect the right of the least advantaged people. Lon Fuller focused on the inner morality of law. So Lon Fuller focused on inner morality of law. He believed that for law to be legitimate, it must follow certain procedural principles like clarity, consistency, and fairness. Clarity, consistency, and fairness. Law, in his view, is a moral enterprise. So he coined the word moral enterprise. Together, these thinkers shaped the version of natural law that rational, ethical, and socially responsive. Let's discuss about analytical school of law. Let's now turn to the analytical school of law. We discussed in detail about analytical law school thinkers in key contributors video, Jeremy Bentham, John Austin, and then HLA Hertz, Kelson. Okay, so as you are aware that for them law is a imperative, means it is a mandatory command given by the sovereign. If anybody doesn't follow this, then there will be sanctions. So it is a command given by highest authority. For example, in India, the parliament for central laws and state governments for state laws, they are going to issue the commands, right? And if anybody is not following, then there will be a punishment or a sanction. So for them, law is an imperative. So that's why it is called as imperative school. This school view law as a command of the sovereign, a rule backed by the authority, such as the central government or a state government who have an authority, and enforced through sanctions. If anybody is not following the law, then there will be a penalty. The founder of this school is Jeremy Bentham, a pioneer legal thinker and also known as a founder of Analytical School. We discussed in detail about his uh, contribution as his view on law. Okay, according to him, a law may be defined as an assemblage of signs, declarative of volition, conceived or adopted by a sovereign in a state. So any rules which is adopted by a sovereign in a state, so those are called as a law for him. And then there is a concept of pain and pleasure which he is introduced. According to him, the law should benefit more people, getting greater happiness for a greater number. Bentham made a key distinction in jurisprudence, expository jurisprudence and also he called as another one is sensorial jurisprudence. Expository jurisprudence, which explains what the law is. Sensorial jurisprudence, it is for critics what the law should be. Okay, so he classified law into two. One is expository and then the other one the sensorial jurisprudence. And this concept of law, according as per Jeremy Bentham, right, it is based on utilitarian individualism, means giving a greatest happiness to the greatest number. So according to the Bentham, every law should be tested against the principle. Does it reduce the pain and increase the pleasure for the majority? Bentham believed that law should eliminate evil, promote pleasure. So eliminate all the pains and then promote pleasure. To meet this, he developed the concept of utilitarian calculus, evaluating law based on the 7 key factors: intensity, how strong is the pleasure or pain; duration, how long does it last; certainty, how likely is it to occur; nearness, how soon it will happen; fecundity, will it lead to a more of the same or there will be any new action; purity, is it free from opposite effect; extent, how many people are affected. So these 7 factors needs to be studied and then decide whether it is a right law or a wrong. This school focuses on law is as it is, read the law as it is and analyze whether it is giving more pleasure or a pain to the larger or a greatest number of people. It laid the groundwork for legal positivism and continues to influence modern legal system. John Austin, who is the father of analytical school, again the detailed discussion is already there in uh, key contributors video. You can refer that or you can refer the notes whatever you made. He is known as father of analytical school. He simply said law is a command by sovereign backed by a sanction. So law is a command given by sovereign and backed by the sanction. So any rules or a law set by it is a sovereign authority, as I told, highest authorities in the country, and this is a command everybody should follow. When we say command means everybody should follow this, and if they are not, they are going to enforce this command by sanctions, which means if people are not following those commands, then there will be a sanction. If people are not following the rules, then they will be punished. If a person violates the traffic rules, then there will be a fine. So 3 essential part of the law: command, sovereign and sanction. So it is based more on analyzing the law. So that's why it is called as analytical school. It is developed in England. It is developed in England. So it is also called as English School of Law. And they are saying that these are command, everybody should follow it. You cannot miss it. So it is a mandatory. So that's why it is called as imperative school of law. And then it is proposed by Austin. So it is Austin's school of law. So these are the various names for analytical school of law. And then we will see the HLA Hart's definition in a brief. So according to HLA Hart's, law consists of rules which are of broad application and no optional in character. So it is a command, everybody should follow law. And he also proposed that law is a union of primary rules and secondary rules, provide key to the science of jurisprudence. Kelson, he promoted a pure theory, studying a law what it is and not what it should be. And he also defined ground norm, the highest norm, which is most highest, and after that superior norm and subordinate norm. For the more details on Austin, Bentham, Hart and Kelson, you can refer the Key Thinkers video. Moving on to Historical School of Law, which offers a very different perspective compared to the analytical school. While analytical thinkers see law as a command from authority, historical jurists believe that law is a product of history. Okay, law is an outcome of history. So law is an outcome of evolutionary forces shaped the society over a time. Yesterday's It may not be a law. Today that might become a law. Okay. Today it is not a law, but tomorrow it might become a law. So it is a evolutionary. It is based on the people and the society. According to this school, law does not emerge suddenly or from a single source. Okay, law does not emerge suddenly or from a single source. Instead, originates from a long drawn process. Okay, how people live in the society. It involves customs, conventions, social habits, customs, conventions, social habits, traditions. Based on that, law will be evolved year on year in a country or in a society. Law is embedded or deeply embedded in the cultural and historical fabric of a society. Key contributors are Montesquieu. According to him, one of the early voices of this school emphasized that law should keep pace with the changing needs of the society. So he clearly said law should keep pace of changing needs of the society. He believed that law must evolve alongside social conditions. It cannot be in isolation. Okay. So he clearly said law should develop alongside social conditions. The most influential figure here is Frederick Carl Savigny. Okay, Savigny is also called as a father of historical school. He proposed Oakgist theory. Oak means people. So we have a Volkswagen car, right? People's car. So Oak means people. Gist means common will. It is a people's will. Okay, so history will be created by people. So it is based on the people's will, the customs, practices, everything, conventions, habits, those will become a law after certain time. Okay. So according to Savigny, law reflects the general will of the people and carries national character. So general will of the people and then it will become a national character. That is what Savigny meant. Let's highlight some of the key principles from Savigny's thought. Law is found, not made. So what are the practice, customs, everything which is following by people that will get converted into law, but it will not be made from the beginning. Law is not universal. It all depends on a cultures and ages. Certain laws may be good in one country, but it may not be accepted in other country. Customs are superior to the law. Okay, customs are superior to the legislation because customs embody the true spirit of the people. Whatever people are following that custom, right? That plays a greater role than a legislation. Legislation is the final stage of lawmaking, not the starting point. So based on the custom, convention and all these things, laws will be made or legislations will be made. So legislation is the last stage, but not the beginning stage of lawmaking. So customs are the beginning stage. The people living, how they are living, those are the initial stages of a law. Another major contributor is Henry Maine, who introduced the evolutionary theory, which is based on the expected future changes law will be developed. Based on whatever changes happens in the society and future changes are going to happen in the society, based on that the laws will be defined. That's why it is called as evolution theory. Let's talk about philosophical ethical school. This school broadly overlaps with the natural law school. Again, moral and ethical grounds are key for this particular school, that is philosophical school of law. The exponent of this school believed that law must be more than just a set of rules. It must carry ethical and moral values, and the law should be for moral purposes. For law to truly command respect in the society, it must reflect the what is right and what is wrong. In this view, law is means to an end. That end being harmonization of individual's will with the general will of the community. So key contributors are Hugo Grotius and Hegel. Hugo Grotius argued that the rule of human conduct emerged from right reason because these rules are grounded in rationality and morality. They naturally receive public support. Grotius laid the groundwork for modern concept of natural rights and international law. Another major contributor is Hegel, who saw law as a tool for reconciling conflict between egos within the society. So most of the things of ethical and philosophical school uh, clashes with natural law or can be merged as a part of natural law school. In this segment, let's explore the sociological school of law, which shifts our focus from abstract theory to a real world impact. It is an extension to the historical school of law. This school believes that law is a social phenomenon. Okay, it doesn't exist in isolation but is deeply connected to human society and behavior. Law evolves within the society. Law evolves within the society and its purpose is to serve social needs and solve social problems. Okay, so it is all about human society and behavior. It studies along with sociology. It believes that law is a social phenomena and it impacts society. So key contributors, let's begin with Auguste Comte, the founder of this school. He viewed society as an organism capable of progress when guided by scientific principles. His idea laid the foundation of understanding law is a dynamic force shaped by the social realities. So Auguste Comte is a founder of sociological school. So for him, society is an organization and it should progress when it is guided by a scientific principles. Okay, it could progress only when it is guided by a scientific principles. Then Duguid, he emphasized that law is essentially and exclusively a social fact. So he clearly said that yes, it is a law is essentially and exclusively a social fact. Social interest is more important than individual interest. So social interest is more important than individual interest here. That is what Duguid suggested. And then law, according to him, law must promote coordination and cooperation among all members of the society. Eugen Enrich took this further by asserting that main source of legal development is society itself. So as a sociological school is always prioritizing that society or a sociology is an important thing. So Elrich, he said main source for any legal development is society itself, not legislators or judicial decisions. Roscoe Pound, who introduced the powerful idea of social engineering. This particular contribution of Roscoe Pound is also discussed in key contribution area in the video number 2. So please refer that for Roscoe Pound's contribution. So he coined the word social engineering. Very simple, how civil engineer focuses on constructing the physical structure. Lawyers are going to construct the societal structure. So he proposed 5 jural postulates for effective social construction, society construction: criminal law, law of patents, law of contracts, law of torts, and strict liability. So it's very important in the sociological school. Roscoe Pound's contribution, where he used the term social engineering and recommended 5 jural postulates. And he compared law with the lawyers with the engineers. Lawyers or engineers are for physical structure, and then lawyers are for maintaining a social order or a social structure. Moving on to a last one, legal realism school, a bold and practical approach to understanding a law, not as it is written, but it is actually applied. So far we discussed, right, law is all about studying what it is, we should not see what it should be and other things. But as per legal realism, this school clearly says that not it is what written, but it is all about how it is applied, how judges will use the written laws, right? How it is actually applied in a decision making or in a judgment. That's the legal realism. This school developed in US. So legal realism challenges that idea that law is fixed set of rules. Instead, it argues that law is shaped by real world factors, especially the behavior and mindset of the judges. It's less about statutes and more about decisions. Okay, so John Gray emphasized that judges' political, economical, and personal qualities play a crucial role in legal decision making. In other words, who the judge is matter just as much as what the law says. Okay, so more important here, the judge's political, economical, and personal qualities play a crucial role when you take a legal decision. So that's why Gray emphasized that who the judge is matters rather than what law says. It is all decisions will be based on a judge and judge's mindset, judge historical uh, strength, political affinement. All these things will shape the judgment. Oliver Oliver Holmes, one of the most influential legal realists, famously said that law is a statement of the circumstances in which public force will be brought to bear upon through courts. Holmes introduced the idea of bad man, someone who does not care about legal theory but only wants to know what court will actually do. For Holmes, law is a blend of experience and logic, not just abstract ideals. Jerome Frank took this further. He believed that while legal rules are applied to a legal facts, there always a possibility of misunderstanding those facts. Right? All the evidences, everything will be seen by the judge, but there is always a possibility of misunderstanding those facts. He argued that certainly of law is a legal myth, certainty of a law is a legal myth. So every time for the same issue, the same punishment, that kind of certainty of law is a myth which is not possible. So this is all about legal realism, where the focus is on constructive process shaped by judges and lawyers, not just by written codes. Curly Levelian, another key realist, viewed law as an institution, a tool to achieve social ends. He believed that law should be in flux, constantly adapting to the changing needs of the society. In essence, legal realism teaches us that law is not just what is written, and it's what is done, how it is applied, how it is used in a decision making. It's shaped by the context of personality and society. Okay, it's shaped by the context, personality, and society. This philosophy brings us closer to the ground reality of how justice is delivered. With this, we conclude our journey through the major schools of law. In the next chapter or in the next video, we will begin exploring the sources of law, where legislations, judge-made laws, and then customs, and also modern sources we will go through in detail. Okay, with this I am concluding this video, and if you found this is helpful, please subscribe to the channel and don't forget to share it with your friends or classmates who might benefit from this content. Thank you so much for watching. Let's meet again in the next video.